Defamation. A libel is public and malicious imputation of a crime or of a vice or defect, real or imaginary, or any act, omission, condition, status, or circumstance tending to cause the dishonor, discredit, or contempt of a natural or juridical person, or to blacken the memory of one who is dead. Article 353. If defamation is committed by means of writing, printing, lithograph, engraving, radio, phonograph, painting, theatrical exhibition, cinematographic exhibition, or any similar means, the crime is libel. Article 355. If it is committed by oral means, the crime is slander or oral defamation. Article 358. If it is committed by performance of an act not punished as libel or slander, which shall cast dishonor, discredit, or contempt upon another person, the crime is slander by deed. Article 359. Elements of defamation. To commit the crime of defamation, libel, oral defamation, and slander by deed, the following requisites must concur. A. The writing, utterance, or acts must be defamatory. B. It must be malicious. C. It must be given publicity. And D. The victim must be identifiable. Defamatory imputation. An allegation is considered defamatory if it ascribes to a person the commission of a crime, that possession of a vice or defect, real or imaginary, or any act, omission, condition, status, or circumstances which tends to dishonor or discredit or put him in contempt, or which tends to blacken the memory of one who is dead. In determining whether a statement is defamatory, the words used are to be construed in their entirety and should be taken in their plain, natural, and ordinary meaning as they would naturally be understood by persons reading them, unless it appears that they were used and understood in another sense. Moreover, a charge is sufficient if the words are calculated to induce the hearers to suppose and understand that the person or persons against whom they were uttered were guilty of certain offenses, or are sufficient to impeach the honesty, virtue, or reputation, or to hold the person or persons up to public ridicule. Manila Bulletin Publishing Corporation versus Domingo. A publisher of the Baguio Daily was sued by Pedro Aguas for libel for the public publication of his picture, with the notice that this is to inform the public that Mr. Pedro Aguas, whose picture appears above, has ceased to be connected with the Sincere Insurance Company as underwriter as of December 31, 1987. Any transaction entered into him after said date will not be honored. 1988. The published notice is not defamatory. It merely informed the public that Pedro Aguas is not anymore connected with the company. Moreover, the publication was not made with dolo, since it is the practice of companies to make notice to the public regarding the non-recognition of transaction with a person who is not anymore connected with the company. This notice is for the protection of the interest of the company and the public as well. Malice. Malice is an element of libel or defamation. There is malice in fact when the author of the imputation is prompted by personal ill will or spite and speaks not in response to duty but merely to injure the reputation of the person who claims to have been defamed. Alonso versus C.A. In Yuchenko versus Alfonso, November 25, 2009, in a span of 1 month, defendants wrote and published and caused the publication of 7 libelous articles against complainant, attacking his honor and reputation as a distinguished businessman, philanthropist, his political inclination, and as an employer in his insurance company. The incessant publication of the defamatory articles attacking the honor and reputation of complainant is a proof of defendant's malicious scheme to malign and defame the name, honor, and reputation of the complainant. There are two kinds of malice: malice in law and malice in fact. Malice in law: every defamatory imputation is presumed to be malicious, even if it be true, if no good intention and justifiable motive for making it is shown. Article 354. When the imputation is defamatory, the prosecution need not prove malice on the part of the defendant, for the law already presumes that the defendant's imputation is malicious. Presumed malice is called malice in law. The burden is on the side of the defendant to show good intention and justifiable motive in order to overcome the legal inference of malice. Malice in fact: the following circumstances will negate the presumption of malice in a defamatory statement. If there is a good intention and justifiable motive for making it is shown. Number 2. If the defamatory statement is a privileged communication. If the defamatory imputation is covered by a qualified privileged communication, defamatory imputation is not presumed to be malicious. Hence, actual malice must be established beyond reasonable doubt to prove the crime of libel or defamation. Actual malice is also known as malice in fact. If the defamatory imputation is covered by an absolute privileged communication, lack of malice in making a defamatory imputation is conclusively presumed. Libel or defamation is not committed because malice in law or in fact, which is an element thereof, is lacking. Publicity: writing to a person other than the person defamed is sufficient to constitute publication. The person to whom the letter is addressed is a third person in relation to its writer and the person defamed therein. The wife of the person defamed is in context a third person to whom the publication was made. Magna versus People. There is publication if the defamatory statement is communicated to a third person. It is not required that the person defamed has read or heard about the libelous remark. What is material is that a third person has read or heard the libelous statement. For a man's reputation is the estimate in which others hold him, not the good opinion which he has of himself. Simply put, in libel, publication means making the defamatory matter, after it is written, known to someone other than the person against whom it has been written. The reason for this is that a communication of the defamatory matter to the person defamed cannot injure his reputation, though it may wound his self-esteem. A man's reputation is not the good opinion he has of himself, but the estimation in which others hold him. Exposing a letter containing defamatory imputation to a third person constitutes publication. Thus, sending a defamatory letter enclosed in a sealed envelope by special messenger to the plaintiff by the defendant is not liable because the element of publication is not present. On the other hand, sending a defamatory letter which is unsealed or not shown to be sealed to a messenger is liable, since the element of publicity is present. People v. Silvella, 1969 bar. A defamatory letter contained in a closed envelope addressed to another constitutes sufficient publication if the offender parted with its possession in such a way that it can be read by person other than the offended party. If a sender of a libelous communication knows or has good reasons to believe that it will be intercepted before reaching the person defamed, there is sufficient publication. The publication of a libel, however, should not be presumed from the fact that the immediate control thereof is parted with unless it appears that there is reasonable probability that it is hereby exposed to be read or seen by third persons. Belen v. People. In Belen v. People, a resolution was issued dismissing a complaint for estafa filed by the accused. He filed a motion for reconsideration with the prosecutor's office and copy furnished to respondent in the estafa case and office of the Secretary of Justice. The motion for reconsideration contains irrelevant and defamatory statement against the investigating prosecutor. Despite the fact that the motion was contained in sealed envelopes, it is not unreasonable to expect that persons other then the one defamed would be able to read the defamatory statement in it. Hence, the elements of publicity in libel is present. Identifiable offended party. To satisfy the element of identifiability, it must be shown that at least a third person or a stranger was able to identify the offended party as the object of the defamatory statement. It is enough if by intrinsic reference the allusion is apparent, or if the publication contains matters of description or reference to facts and circumstances from which others reading the article may know the person alluded to, or if the latter is pointed out by extraneous circumstances so that those knowing such person could and did understand that he was the person referred to. In Diaz versus People, a libellous article defaming Miss S does not give a sufficient description or other indications which identify Miss S. In short, the article fails to show that Miss S and the complainant are one and the same person. Although the article is libellous, complainant could not have been the person defamed therein. Because of a pendency of a labor dispute, two belligerent labor unions had confrontation in a picket line, during which the president and the secretary of one union shouted to the members and officers of the rival union composed of men and women the following: "Mga supot, mga walang bayag, mga kabit ng inchik, mga tuta, mga segundo mano." The president and the secretary of said union are not liable for oral defamation because the element of identifiability of the persons defamed is not present. 1993. In Manila Bulletin Publishing Corporation versus Domingo, the accused published an article where he stated that these national employees should be commended for bringing into the open this garbage that has piled up in their own backyard. To Joe Khan's successor, the chopping board is ready. All you need is a Muslim, Chris. Palakulin mo, pare ko. This is not libellous. On the first statement, accused is merely commending the DTI employees who brought into the open their complaints against the private complainant, in this case, a DTI officer. This is a fair remark. The last three sentences merely meant that heads should roll at the DTI office, which does not ascribe something deprecating against complainant. Moreover, the statement does not refer to an ascertained or ascertainable person. In People versus Aquino, Corazon, Aquino uttered in public, "You, Mirera lawyers, are stealers, shameless, impolite." The accused was convicted of oral defamation. The offended parties are identifiable. They are lawyers belonging to the Mirera family. Members of a particular group can be offended parties in libel. People versus Aquino. However, if the membership of the group is so large, the element of identifiability of the offended parties is not present. Thus, one who published a statement, "Lahat ng Amerikano ay manyak," is not liable for libel. Declarations made about a large class of people cannot be interpreted to advert to an identified or identifiable individual. A lecture imputing corruption in Bureau of Customs and the Bureau of Internal Revenue is not actionable absent circumstances specifically pointing the defamation to particular persons. 2003. In MVRS Publications versus Islamic Dawah Council of the Philippines, the accused wrote in a newspaper Bulgar na ang mga baboy at kahit anong uri ng hayop sa Mindanao ay hindi kinakain ng mga Muslim. Para sa kanila, ang mga ito ay isang sagradong bagay. Hindi nila ito kailangang kainin kahit na sila pa ay nagutom at mawala ng ulam sa tuwing sila ay kakain. Ginagawa nila itong Diyos at sinasamba pa nila ito sa tuwing araw ng kanilang pangilingilin, lalong-lalo na sa araw na tinatawag nilang Ramadan. The accused was acquitted of libel because the identifiability of the offended parties, which is an element of libel, is not present. The Muslim community is too vast as to readily ascertain who among the Muslims were particularly defamed. The size of the group renders the reference as an indeterminate and generic as a similar attack on Catholics, Protestants, Buddhists, or Mormons would do. In Eliseo Soriano versus People, the accused Soriano, through a religious radio program, Ang Dating Daan, authored and described the members of Jesus Miracle Crusade as isang dakot na gago and siraulo. The information does not refer to any specific individual or pastor, but merely mentions persons comprising the Jesus Miracle Crusade international ministry. The defamatory statement do not single out any specific pastor, and they are not sweeping enough as to injure the reputation of all the members of JMC-IM. The accused is acquitted of the charge of libel. Libel or written defamation. A libel is omitted by means of writing, printing, lithography, engraving, radio, phonograph, printing, theatrical exhibition, cinematographic exhibition, or any similar means. Defamatory imputations which are made not by publication in the newspapers but by broadcast over the radio constitute libel. 2002. Writing, printing, radio, etc. have a common characteristic, and that is their permanent nature as a means of publication, and this explains the graver penalty for libel than that prescribed for oral defamation. Hence, the phrase "any similar means" in Article 355 should be understood in the light of the said common characteristic of the means to commit libel. Thus, defamation through an amplifier constitutes oral defamation under Article 358, and not libel under Article 355, since its nature as means of publication is not permanent, and thus it is not similar to radio or other means mentioned in Article 355. People versus Santiago. On the other hand, television, though not expressly mentioned in Article 355, easily qualifies under the general provision or any similar means. People versus Castan. Since the nature of Internet as a means of publication is permanent, it should be considered as a means to commit libel. Libel is not a constitutionally protected speech, and that the government has an obligation to protect private individuals from defamation. Indeed, cyber libel is actually not a new crime, since Article 353 in relation to Article 355 of the Revised Penal Code already punishes it. Online defamation constitutes similar means for committing libel. Disseny versus Secretary of Justice. Persons responsible for libel, and a person who shall publish, exhibit, or cause the publication or exhibition of any defamation in writing or by similar means shall be responsible for the same. The author or editor of a book or pamphlet, or the editor or business manager of a daily newspaper, magazine, or serial publication shall be responsible for the defamation contained therein to the same extent as if he were the author thereof. Article 360. In Erwin Tulfer versus People, the claim of editors and president of Remate, the paper on which the defamatory articles appeared, that they had no participation does not shield them from liability. Article 360 does not provide absence of participation as a defense, but rather plainly and specifically states the responsibility of those involved in publishing newspapers and other periodicals. It is not a matter of whether or not they conspired in preparing and publishing the subject articles, because the law simply so states that they are liable as they were the author. Neither the publishers nor the editors can disclaim liability for libelous articles that appear on their paper by simply saying they had no participation in the preparation of the same. They cannot say that Tulfu was all alone in the publication of Remate, on which the subject articles appeared, when they themselves clearly hold positions of authority in the newspaper or as the president in the publishing company. 2016.